All right, welcome everybody to our first in meeting of the new year. We didn't meet in January, as you might have figured out, but we're back here together again, still remotely. And so I appreciate as I look out in front of everybody that's in our main group that none of them so far has decided to put a cat filter on. I'm hoping that maybe someone's going to work that in to the presentation this evening, but so far no one has. If you don't know what I'm talking about, take a few moments after our meeting and just type in lawyer cat filter. It'll be the best 45 seconds of your day, I guarantee you. Those of you that have seen that video already understand what it means to go, I don't know how to get this thing off, because that's what happened to that lawyer. So welcome to our meeting. We've got a couple of things that I wanted to take care of, but I meant to take care of sooner. And so one of the things that's true is we have a practice, a history of honoring those people that have served as officers for our Inn chapter after they decide that they are retiring. And I use that term in quotation marks because I don't think we ever get to retire from the Inn. I think you're just no longer actively serving as an officer until we can finagle your way back in. But I want to recognize two of those people that were officers during the early part of my term as president that are no longer as part of our officer team. And so the first of those persons is Deborah Nash, who was our vice president. I know Deborah is on the call with us this evening. The other person is Leslie Adams, and she should be with us as well. And so I believe we have plaques for them, and I don't know, Lou or Larry, whether we have the ability to show those plaques that we're going to give them for their years of service. And I don't know if we have the ability to let either one of them make a brief statement, but I know Deborah's on the team that's presenting this evening, so I know she should have some privileges that allow her to go ahead and unmute herself and make a brief statement. So let me turn it over to Deborah and see if she'd like to say anything to the rest of the Inn.
Well, just that it's been my honor. I've been with the Inn at various points in my career since the Inn started, and it's always been an honor to be a part of the Inn and North County and the bar, and to see people just start out young lawyers. And when I was a medium lawyer, and sort of all grow together, go our different ways, and be able to come back in. And it's always been a great source of pride and pleasure in. So thank you.
Thank you. I thank you personally for all the help that you gave us, Deborah, especially me personally. When I first took over as president, Judge Casserly was kind enough to encourage me to step into that role. And I had no clue of what I was doing. And both you and Judge Casserly helped guide me to make sure I didn't let the wheels fall completely off this Inn chapter. So I thank you for all your wise counsel to me those years as you were my vice president. Thank you so much from the bottom of my heart. And I know Leslie should be on the call with us too, but I think because we're doing this in seminar mode that we don't have the ability to get her on. So we'll figure out how to get her in the future so she can also make whatever comments that she would like to make to the rest of the group. So thank you, Deborah. Thank you, Leslie, for your years of service, and enjoy the time that you're not in office, because like I said, we're going to try to figure out a way to get you back in office with us before too long. Let me next turn to our membership chair, if Eric's available and he has any comments that he would like to make to the group.
I don't have very many comments. We are stuck in the COVID zone, difficult to recruit, difficult to bring people in and to give them the full force and the full experience of the Inn. But nonetheless, to take some burden off of people, if you would like to refer any of your friends to me, I will gladly reach out to them personally. And I'm going to type my email address into the chat bar here shortly so that you can send them my way. I'll give you my email address and my phone number and send them out. And if you don't want to do that, reach out to them and bring them to the next meeting. We We had one prospective guest who had to postpone until the next meeting, but let's see if we can get some. I'm more than willing to put the work in. We're at 63 active members, which is the same as last time. And let's see what we can do. You know, the year is moving fast. Maybe we'll actually be able to get together by fall. So thanks again, Judge Washington.
Thanks so much, Eric. I appreciate that. And yeah, I appreciate the fact that you're going to put your email in the chat. So if anybody knows anyone that you think, hey, I don't know if I could have gotten them to the Carlsbad Senior Center, but I might be able to get them on a Zoom call on a Wednesday evening, feel free to let Eric know. He'll reach out to them, or let any of the officers, frankly, know, and we can reach out to them and try to encourage them to join us during this very different year. Let me turn next to Randy and see if there's anything from our treasurer's report. Randy?
Yes, thank you, Judge Washington. Hopefully I'm not muted. No, I'm not. Real brief report. As always, there's some good news and some bad news. I'll start with the bad news. We're behind on our collections, and our year-to-date profit and loss shows a loss of $1,355. In other words, our expenses have exceeded our income. A little bit of good news is we still have about 30 open invoices by my count, and I've just sent out a reminder to people, if you haven't paid your dues, or let's put it this way, if my records don't reflect you've paid your dues, you're getting a reminder, and then you can let me know either A, or leave your records are wrong and you've overlooked my payment, which is possible, or oops, I haven't paid my dues, and get those paid, because I want to get us into the black for this year as soon as possible. We need about, we really need all 30 members to go ahead and pay their dues. The other good news is we're solvent. We have money in reserve, but we really do need to get the financial statement in shape for this current term. So that's all I have, Judge Washington. Financially, we're stable, but we're lagging on our dues.
Okay, I appreciate that, Randy. And you know, that tends to historically be a problem. I think it's even more a problem in this virtual age. But again, I join Randy in encouraging people that if you haven't paid, let them know. I see a message from Phyllis Brown, so we'll check into that and find out what's going on and make sure everybody that's trying to pay their dues is certainly able to pay their dues. Are there any other officers that have any announcements that they'd like to make this evening? Raise your hand or unmute your device and just go ahead and let me know. And I don't hear anything. I want to let everybody know I did have a conversation with the president of the North County Bar Association. One of the things that we talked about is perhaps later this spring, or as we get into summer, one of our last two programs, we might try to combine it with the North County Bar, with the expectation that since they're meeting virtually, we're meeting virtually, that we can try to recruit a speaker that might be of a bit more prominence that we would otherwise be able to get, because they wouldn't have to come to Carlsbad or Vista to meet with our groups. And so if we're able to do that, we'll certainly let everybody know who that speaker is and what we expect to get from them. The other thing we're talking about as inn leaders is, what do we want to do about the joint inns dinner January of next year? Because for the inn, and it's not us, once again, fortunately, everything just keeps rolling forward. So our opportunity to host it keeps getting moved back. But for the inn that's hosting it, they're wondering if it's worth trying to plan to host it in January, given the fact that vaccines are just rolling out and venues are still not sure whether they want to plan to host in a big event like that. Again, it's likely that they're going to hold off on that decision, but we'll probably send a survey out in the next couple of weeks before the end of the month to see what your thoughts are on whether we should whether you'd be interested, let me put it differently, whether you'd be interested in attending an in-person joint dinners event in January of 2022, whether you'd be interested in attending a virtual but not in-person event, or whether you're just not interested in doing either one until sometime further in the future. it's like people asking me about what we're doing at the court. The future continues to be so unpredictable that I have no ability to state with any certainty what we're doing or what the future looks like. And I think that seems to be the situation that we've had now for, it's hard to believe, it's almost been exactly 11 months to the day since we first closed because of the pandemic, and we're still not letting the public in a meaningful way at our courthouse. So everybody's been impacted by it, and we're trying to figure out how best to proceed. Speaking of things that I think I do know about 2021, though, is I know that the team that's presenting tonight is led by my colleague, Judge Tim Cashley, and I have it on good authority that he knows in 2021 that this is going to be his last year as an active judge on the bench. So I can say with some sadness that I haven't known a time that I've been in Vista, and I came up to Vista in 1995 when Judge Cashley wasn't there. I've had the pleasure of appearing in front of him numerous times when I was an attorney, and now it's a great thrill to be a colleague of his. I've told him personally, but I'll say publicly, he's one of the people that's been a mentor of mine. He was a role model of mine as I became a young judge. And I think I still do some things in part because I saw Judge Cashley do it. And I loved when I saw him do it when he was presiding over cases and I was an attorney either in front of him or sitting in the back of the courtroom watching someone else get grilled. And so I think I grilled some people today, and I'll have my personal homage to Judge Cashley on the way that he would question attorneys to make sure they knew what they were talking about when they appeared in front of him. I know it made me a better attorney, and my hope is the same. So I'm excited to see what he's done with his team in this presentation this evening, because that's just the type of leader he is. And so with that, I'm going to back out of the way, and I'm going to turn it over to my colleague, Judge Tim Casserly. Tim.
All right. So I guess we're ready to start. I do have to say to Judge Washington, you know, I was thinking yesterday, I was reminiscing. It's a long story why, but I was going back through my whole career on the bench, and I was thinking, didn't we have a lot of fun in Department 5? And I was thinking about back in the day, we talked about, because everybody used to have to come, all the criminal lawyers had to come to my department every day, and we'd meet in chambers and discuss the cases. And we had a rule in chambers that anything goes in chambers. You could say anything. And people would start talking about like what their defenses were, and other lawyers would laugh and say, no, that's not going to work. And we talked about, we should make a TV show out of this. We had so much fun. You know, then we go out on the record and do serious stuff. But back in chambers where the sausage was being made, I mean, I had a lot of fun. I don't know about you.
I had a great time.
Yeah, that was fun. That was part of my philosophy. I always thought, you know, this is hard, serious work that we're doing, but there's no reason we can't have fun with it also. That was kind of my thought.
I agree.
So anyways, I guess we should get back to get to our program tonight. Our team, the topic for our team is lawyers as employers. And tonight we're going to discuss different issues who we are or will be facing in the coming months, whether you're a lawyer who is an employer or a lawyer who is an employee. We will be discussing as part of this COVID issues because we have to. There's just no getting around it. We'll also be discussing working from home and the various issues that have or will arise, whether work from home becomes permanent, as well as transitioning from work from home back to the office. Lastly, we will discuss new laws in 2021 that will affect all of us. So we're going to use some vignettes tonight. Vignette number one, the first topic in our presentation will be a work from home and various labor laws. Our first vignette will show 3 employers discussing what has been brought to their attention from several employees. The time frame is late summer 2020, but these issues continue today.
So, after working from home for several months, a number of issues have been brought to my attention from a few employees. Jack noticed that after months and months of work from home, his utilities have gone up and he thinks the company should pay the difference.
What? That's crazy. Jack was commuting 20 miles each way in his F-350. That thing seriously got no more than 8 miles to the gallon. Now he's not commuting at all. And how do we know, or his whole family for that matter, is energy efficient? Have you ever been to his house? They have a pool they keep heated year round. Doesn't he have like 5 kids who are at home from school right now? Is he using low flush toilets and fluorescent lights like we do at the office? I would want to see all his energy bills before and after, but the next thing you know, he'll be saying we're invading his privacy.
Well, I think we have to consider the fact that our employees may actually have higher costs than that they didn't have when they were working from the office. Labor Code Section 2802, that's 2802, requires employers to reimburse business-related expenses such as equipment, materials, training, business travel, and uniforms. Isn't it like when we had to pay for all their new computers and laptops that they needed to work from home in the first place?
That's a good point, but I think the firm can weigh their increased costs against what they are saving. No more commute, so less gas, no more parking fees, less dry cleaning.
They sure are spending a little less on dry cleaning. Most of them are wearing their pajamas on the last office Zoom call.
Well, I don't think we can start analyzing everyone's SDG&E bill, but maybe we can come up with a fair amount that will make everyone feel like we're actually listening to their concerns about working from home, increasing their overhead, as well as reminding them of the costs that they've been saving. And remember, we need to let payroll know what this extra amount is for, so it can be accurately noted on their paychecks. Otherwise, we may end up with Labor Code Section 226 problems. An employer must provide employees with the right to receive an accurate record of the hours they work, their rate of pay, the wages they were paid, and deductions from their gross wages. I also think we need to consider partial reimbursements for their cell phones. I know that they are actually texting each other a lot more now than when they were in the office and they could simply just get up from their desks to go speak with one another.
Well, another issue has been brought to my attention from Mary. She is the new assistant who is non-exempt, meaning she is hourly. She said that since we had to cut staff, more and more responsibility has fallen to her, but she's not getting any breaks, lunches, or overtime.
Yeah, right. I'm friends with her on Facebook and she has like 5 dogs. I'm sure she's out walking her dogs half the day. She's also in some wine box of the month club, so she's probably drunk the other half and loving it because we can't smell the alcohol on her.
Okay, Craig, Mary with the drunken wine and the 5 dogs has actually tracked all her hours to tasks that she's been performing, and I think she has a valid concern. We have to make sure that the non-exempts are taking their breaks and getting overtime when applicable while they're working from home. While we have all of our employees, staff, and attorneys manually tracking their time, I think it's time that we look into employee productivity tracking software to track employees' work hours or productivity, monitor their activity over our company electronic resources, or protect trade secrets and proprietary information. I know that employers that use technology to monitor their remote employees might need to disclose their data collection and use practices to those employees. Employers are required to comply with the California Consumer Privacy Act, or the CCPA, must provide notice to employees regarding any personal information collected and how such information is used. The truth is, employees probably waste a lot more time at the office as well by chatting with their other coworkers at work, in the coffee room, in the break room. And I've seen studies where some employees are much more productive when they're working from home. So we need to be mindful about following California labor laws while everyone's working from home.
All right, we will now move on to vignette number 2. The second topic in our presentation will be transitioning an office from work from home to back to the office. Our second vignette will show 3 employees on Zoom discussing coming back to the office. The time frame is now in 2021.
So what do you think about having to go back to the office on March 1st, 2021?
Ugh, I don't want to have to go back and get the vaccine or get a COVID test. I like working from home. It's safer. Can I just tell them that I have COVID so I can stay at home?
Well, an employer doesn't have to allow employees to work from home, but an employee can ask for an accommodation if necessary. Then the employer and the employee could engage in the interactive process and come to a resolution. But if an employer requires employees to come to the office, they should still maintain safety protocols.
But I like working in my sweatpants. Would that warrant an accommodation?
Probably not. Our employer could ask for a note from your doctor to support the accommodation that you're requesting. So for instance, if you really were brave enough to tell our employer that you had COVID, they could ask for a doctor's note to support your claim.
No, they can't. That would violate HIPAA, wouldn't it?
Nope. The ADA permits employers to make disability-related inquiries, and they can conduct a medical exam if it's job-related and consistent with business necessity. So I think you're saying that you had COVID would be a business necessity in this case. If our employer did that, they'd be acting in accordance with the ADA as long as the screening implemented is consistent with the advice from the CDC and other healthcare professionals, and it's consistent with the workplace and the time. For instance, right now, our employers could ask to take our temperature, and they could ask us about symptoms of COVID that we may be experiencing. Self-reporting is permitted right now in the workplace. So as long as the employers and employees follow guidelines from the CDC of control, disease control and prevention, then our employer is on firm ground because they have to protect the workers, vendors, clients, and the public, basically everyone. So,
What about the,
go
sorry,
ahead.
So what would
sorry.
go ahead.
Go ahead, go on.
So what would happen if I refuse to let them take my temperature, or if I refuse to tell them if I have any COVID symptoms?
Well, under the circumstances, the ADA allows the employer to bar you from the workplace if you have COVID-19, symptoms of COVID-19, or you've been tested for COVID-19. So the employer may ask for your refusal to come to the workplace to try to work with you, but they still have to ensure the safety of everyone that comes into contact at the workplace. So sometimes it's just a matter of what your concern is. If you're just concerned that our employer will share medical information, then I would think they should work with you and let you know that your private medical information won't be disclosed.
Okay, so what if someone has COVID and then comes to work?
Well, I recently read that AB 685 imposes new reporting requirements on our employer to track COVID-19 cases in the workplace. So starting with January 1st, employers are required to notify us, any employees of any subcontractors or workers and union representatives, that if they've come in contact with anyone that has been diagnosed with COVID-19 or was suspected to be diagnosed of or to be in contact with someone with COVID-19, then they have to notify us within 1 business day. And so based on any positive confirmed cases of COVID-19 in the workplace, we must be able to get written notice from our employers. They must also give us at the same time written notice regarding any benefits that we get. And that would include workers' compensation, COVID-19 leave, paid sick leave, as well as copies of the company's policy on anti-discrimination, anti-harassment, and anti-retaliation. They must also provide us notice about their disinfectant policies and what they're going to do to keep us safe to prevent future outbreaks. So if there is an outbreak of COVID-19, which is basically 3 cases within a 2-week period, then the employer must also report the outbreak to the local health department within 48 hours.
I also read that SB 1159, which codifies the COVID-19 presumption created by Executive Order N6220, provides 2 new rebuttable presumptions that an employee's COVID-19 illness is an occupational injury and therefore eligible for workers' compensation benefits if specified criteria are met. Employees who are sick can stay home and be provided workers' compensation benefits, thereby reducing the spread of the virus to others at work and in the community.
So if I get COVID at Walmart, I can get workers' comp.
Yes, it looks that way.
All right, we'll move on to vignette number 3. In this one, in our series of lawyer as employer concerns hiring in the age of COVID and beyond, featuring an attorney consulting with an employment attorney regarding the hiring of new attorneys and support staff.
Hi, Catherine. Thanks so much for consulting with me. Although I believe I'm competent and qualified in the areas of HOA and real estate law, California employment law issues absolutely terrify me. It just seems so arbitrary and full of landmines, and the laws and the regulations are changing all the time. I'm afraid I'm going to ask some forbidden question and hurt somebody's fees. I don't know what to do.
Well, you are wise to seek counsel. So employment law has many, many traps for the unwary and for the wary alike. And many employers have found themselves on the pointy end of an employment law claim.
I know I want to hire the best people I can, but I also really don't want to get sued or deal with the Department of Labor. That's just going to soak up my time and money and peace of mind. It's unfortunate that it has to be such a big consideration, but here we are.
Yes, here we are. So it sounds like you're hiring. Is that correct?
We're hiring. We're looking to hire a support staff employee who will need to be in the office. This whole COVID disaster has put another layer of complexity to our hiring decision. You know what drives me crazy, Catherine? Seeing people driving around in their cars by themselves with a mask on. People walking along the beach on a windy day all by themselves, nobody around, but they're wearing a freaking mask. You're in a grocery store or some other crowded place, I get it, wear the mask. If that's the case, we should have always been wearing masks and standing 6 feet away from each other. And I have no doubt that wearing masks and social distancing will be around forever. We're never going to build back better. It's already 2021 and we're still dealing with COVID-19 with more mutant strains on the way, just like I predicted when the Rona first hit. So that's a long way of me saying, I want to ask support staff employees if they want everyone else in the office to wear a mask. Can I do that? It doesn't seem to have anything to do with a disability or a reasonable accommodation as far as I can tell, but maybe there are OSHA regulations or some other emergency legislation that is relevant.
Well, you hit the nail on the head. There are Cal OSHA emergency temporary standards designed to assist employers with safety protocols. The physical distancing requirements of the ETS, which is this emergency temporary standard, so we call it the ETS, sets forth that an employer must ensure that employees maintain at least 6 feet of distance from other persons unless it is not possible. You're in a law office, it's probably possible. In which case, employees should be as far from others as possible if they can't be 6 feet away. So momentary contact closer than 6 feet while in movement, you're passing each other, that's okay. It's not considered a violation. But you have to be prepared to show Cal OSHA why, if you're not physical distancing, why it's not possible. So it sounds like you can comply with this standard of the ETS.
Yeah, well, it's generally just my office manager and I at the office with my partner and my associate working almost entirely from home. My office manager brings her 7-year-old so he can Zoom school to kindergarten from one of our vacant offices. None of us wants to wear a mask. We hate wearing masks. So we don't have to wear masks?
Well, not quite. The ETS does require employers that you provide employees with face coverings or you reimburse them for the cost. And you ensure that they are worn over the nose and mouth when indoors and when outdoors closer than 6 feet. So exceptions do exist, and those include when the employee is alone in a room, like when you can shut the door to your office, when eating or drinking, when using a respirator or other respirator protection that may not apply to you, or when an employee cannot use a face covering due to a medical condition. If you're hearing impaired, so you're communicating with someone using sign language, or they need to read your lips, or when a specific task cannot be performed with a face covering. For lawyers, most of our tasks can be performed with the face covering, but other measures to protect against COVID-19 must be implemented if you can't wear the face coverings.
Well, a few of my employees might qualify under having a mental condition. So if we hire a new person, are we going to have to wear masks?
Well, when hiring, I would suggest that you let the potential employee know that you are following the Cal OSHA standards. And just like at hiring at any other time, you'll kind of know if the employee will fit with your culture of your office. You may ask them, if you're 6 feet apart, if they would prefer you to interview without your mask on. If they say they want you to keep your mask on, you'll probably know right there that they may not be a cultural fit for your office.
Well, thanks, Catherine. Part of me wants to wait for things to go back to normal before hiring anyone. But since I know that's never going to happen, I'll have to try to do the best I can to hire someone who shares our same perspective on life without getting sued.
All right. Our next vignette, two employers are going to talk about employment issues that relate to the vaccine and paying employees who have to quarantine.
So Paula, I've been reading up about how the vaccine will affect our responsibility as employers with respect to our employees. I've been hearing that a few of our employees have already received the vaccine. Once an employee is vaccinated, must the OSHA Emergency Temporary Standards, ETS, still be followed for vaccinated persons?
Well, for now, all prevention measures must continue to be implemented. The impact of vaccines will likely be addressed in a future revision to the Emergency Temporary Standards, the ETS.
Well, I hear a lot of talk from other employees who say they will not get the vaccine. What are your thoughts about mandating our employees to get the vaccine?
This is a polarizing topic right now, and I just don't have all the answers. Healthcare, travel, retail, other businesses whose employees are at risk or who present a risk to others will have more business reasons to be pro-vaccine. But in an industry like ours, where people can work remotely or be able to social distance in the office, attorneys may find it easier to take a personal choice stance.
Well, I'm concerned about getting sued by employees who say we are not providing a safe environment. Because if a mandatory vaccination policy is not imposed, employees may allege that we have failed to provide a safe and healthy work environment, which is required by the Occupational Safety and Health Act, OSHA.
Well, on the other hand, and in my opinion, it would be breaking new ground to hold an employer liable for not requiring vaccination. Exceptions must be made for employees who cannot be vaccinated because of disabilities or due to a sincerely held religious belief. But employers do not have to accommodate secular or medical beliefs about vaccines.
Well, good luck with balancing secular views and beliefs from sincerely held religious beliefs. If an employee requests an accommodation because they say they can't get the vaccine, and an employer has an objective basis for questioning the sincerity of that belief or practice, I know we can request supporting information from the employee.
Well, if public health authority guidance adopts the view that employers should not permit unvaccinated employees into the workplace, well, litigation is just going to boom in the coming years over whether appropriate safety protocols were followed by an employer versus an employee's rights. I guess that's good news for some lawyers.
True, but what happens if an employee has to quarantine because of COVID exposure, or if they test positive? Do we still have to pay them?
Good question. Some of the relief efforts that were in place expired on December 31st of last year. It included paid leave for certain COVID-19 related absences and mandatory paid sick time. If an employer voluntarily chooses to keep these relief efforts in place, there are some tax credits, but we're not going to get into those right now without the assistance of our CPA.
All right, well, are workers eligible for unemployment benefits if they have symptoms of COVID-19 and seek a diagnosis? Or if they are diagnosed with COVID-19 and forced to take unpaid time off from work?
Well, yes, and a positive COVID-19 test is not required. Also, workers are eligible for unemployment benefits if their childcare facility is closed after school was scheduled to adjourn for the year.
All right, now we're going to hear from Susan and Catherine regarding a few laws that have changed in 2021 that we need to be aware of. You will receive a handout that includes more detail on these laws and others.
So this is the part where we're going to get a little technical. So Susan and I are going to try to talk slow and make sure you guys can write down some of these things. AB 1281, all of these are kind of new laws or additions to expansions of current laws. So AB 1281, which is the California Consumer Privacy Act, or CCPA, amendments and regulations. AB 1281 amends section 1798.145, 1798.145 of the Civil Code, as was approved by Governor Newsom on September 29th, 2020. It extends the exemptions under the California Consumer Privacy Act for personal information collected and shared in employment and business-to-business contacts through the end of this year, so through December 31st, 2021. And there will be more on our handout about these things.
So the next one we're going to talk about is a small employer family leave mediation pilot program under AB 1867. So the California Department of Fair Employment and Housing, commonly called the DFEH, which most of us know, has, among other things, power to investigate, mediate, and prosecute complaints by employees or former employees under FEHA. AB 1867 requires the DFEH to create a small employer family leave mediation pilot program, which would authorize a small employer or the employee to request that all parties participate in mediation through the DFEH Dispute Resolution Division. If mediation is requested, this bill would prohibit the employee from pursuing a civil action until the mediation is complete, and the statute of limitations would be told for the employee to bring a civil claim. This program is going to expire as of January 1st, 2024.
Okay, so this next one has to do with, we're going to get some more attorneys' fees being awarded. So AB 1947, it's the time period for filing a DLSE complaint, a Division of Labor Standards Enforcement complaint. This one will extend the time period for those employees who believe they have been discharged or otherwise discriminated against in violation of any law enforced by the Labor Commissioner. To file with the DLSE, it takes it from 6 months, now they have a year to do that filing. So it expands that time. It also authorizes the court to award reasonable attorney's fees to a plaintiff, not a prevailing party, but the plaintiff who successfully brings a whistleblower action under Labor Code 1102.5. So prior to AB 1947's, workers who prevailed in lawsuits alleging that their employer made, adopted, or enforced a policy that prevented them from disclosing information to a government or law enforcement agency, where they had reasonable cause to believe that the information disclosed a violation of a state or federal law could obtain damages, they weren't permitted to seek attorney's fees. Now this law expands it so they can now seek those attorney's fees via the statute. It will amend sections 98.7 and 1102.5 of the Labor Code.
So now we're going to talk about Assembly Bill 5, which is California's statute governing the classification of independent contractors versus an employee. So Assembly Bill 5 underwent fundamental changes on September 4th, 2020, when Assembly Bill 2257 became law. There are now many more exemptions to the former law governing who can be an IC or independent contractor versus whether or not they are properly classified as an employee or IC. I think we all have been following this. The new exemptions and revisions apply to exemptions for business-to-business relationships, referral agencies, professional services, performance artists, and other classifications. So AB 5 codified the rigid ABC test for determining whether a worker is properly classified as an independent contractor. If the AB test fails, the worker must be classified as an employee and provided the full complement of legal protections which employee status affords. So to pass the ABC test, 3 factors must be present. The first one is the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract and in fact. The second factor is the worker performs work that's outside the usual course of the hiring entity's business. And the last factor is the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So if a company is unable to demonstrate any of these 3 factors, then the worker is an employee subject to the list of exemptions. So now, by enacting AB 2257, many more California workers will be exempted from the ABC test. In all, there are now 109 categories exempted from the ABC test in California under AB 2257. Notably absent from the new exemptions are the California trucking industry, which, as many of us know, that's the Dynamex case was involves the trucking industry. The gig economy companies, although that was changed again when voters supported Proposition 22, and motion picture and television industries, despite significant lobbying efforts. Although the ABC test still applies in many circumstances, AB 2257 establishes much more flexible standards in the following areas. Again, business-to-business relationships, referral agencies, and professional services. Moreover, it exempts additional occupations and business relationships.
SB 1159, this is workers' compensation. So COVID-19 for critical workers. So just as you saw in the vignette where they said, oh, so if I get it at Walmart, I get workers' comp. These laws will now give you some restrictions for those. So SB 1159, it codifies and supersedes Governor Newsom's executive order N6220, which created COVID-19 presumptions that an employee's illness related to coronavirus is an occupational injury and therefore eligible for workers' compensation benefits if specified criteria are met. So the bill addresses employees who get sick or injured due to COVID-19 on or after July 6th, 2020. So it creates a presumption that any COVID-19 related illness of an employee was presumed to arise out of and in the course of employment for purposes of awarding workers' compensation benefits if all of the following criteria are satisfied. So the first one is kind of the important one, that the employee tested positive for or was diagnosed with COVID-19 within 14 days after a day that the employee performed labor or services at the place of employment at the employer's direction. Okay, so that's your first step. Then, if on that day the employee performed services, it was after March 19th, 2020. Okay. Then the employee's place of employment, employee's place of employment was not the employee's home, so they can't get it if they're working from home. And if the employee was diagnosed, not tested as provided in our first statement 14 days after, and the diagnosis was done by a physician who holds a physician and surgeon license issued by the California Medical Board, and that diagnosis is confirmed by further testing within 30 days of the date of diagnosis. So now there's a couple more things that they need to do. They can't just say, oh, I have COVID and go get workers' comp. So there's a few more requirements. So Susan?
I think that's it.
So yeah, Judge Massey.
All right. I believe that concludes our program.
Does anybody have any questions they want to throw out in the Q&A?
That's what I was going to ask. If there are any questions, I was fascinated to learn all of those requirements with COVID now in 2020 and 2021. I was amazed that there's that much that needs to be done. I salute you guys for doing a great job with the research on that. I see there's only one message in the chat. That's from Anna saying, great job. Anybody else, you can type a message in the chat if you like. If you have a question for the group. If not, thank you, Judge Casserly, for your group and your presentation. Thank you to everybody that was a part of the team tonight. You guys did a really nice job presenting the challenges and the opportunities for employers in the age of COVID and the responsibilities as a lawyer, as an employer. And we look forward to seeing everybody in a month, March 10th, back here. Thank you, everyone. Have a great evening.